In the matter of Wikimedia Foundation Inc. versus ANI Media Private Limited, Supreme Court set aside the directions contained in Para 5 of Impugned Order dated 16 October 2024. On 17 September 2024, an opinion piece was published in the Indian Express e-edition titled Why the Case Against Wikipedia in India is a Challenge to Freedom of Speech and Information. It was also hosted in the platform of the appellant. In the piece, it was mentioned that while issuing contempt notice, the learned single judge had reportedly said, if you don't like India, please don't work in India. We will ask the government to block your site. Observing that there could be a failure to understand the nature of the medium that is Wikipedia, it was commented upon that the court's decision to hold some members accountable and punish a community of volunteers by disclosing their private information seems to be a challenge to freedom of speech and information. The effect this would produce is that any form of critical information that a powerful organization does not like can be censored or become grounds for punishment, which would set a wrong precedent. Supreme Court said that we are primarily concerned with the legality and propriety of the direction of the High Court to appellant to take down or delete the pages and discussion with regard to observations made by the High Court. That is the width and scope of this appeal. Nine-judge bench decision in Naresh Sridhar Mirjakar trial, held subject to the public scrutiny and gaze, naturally acts as a check against judicial caprice or vagaries and serves as a powerful instrument for creating confidence of the public in the fairness, objectivity, and impartiality of the administration of justice. Courts, as a public and open institution, must always remain open to public observations, debates, and criticisms. In fact, courts should welcome debates and constructive criticism. Every important issue needs to be vigorously debated by the people and the press, even if the issue of debate is sub judice before a court. However, those who offer criticism should remember that judges cannot respond to such criticism. But if a publication scandalizes the court or a judge or judges, and if a case of contempt is made out as highlighted by Justice Iyer in his principle, certainly courts should take action. But it is not the duty of the court to tell the media delete this or take that down. For the improvement of any system, and that includes the judiciary, introspection is a key. That can happen only if there is a robust debate, even on issues which are before the court. Both the judiciary and the media are foundational pillars of democracy, which is a basic feature of our constitution. For a liberal democracy to thrive, both must supplement each other. Though the contention of the appellant is that it is an intermediary in terms of Section 21W read with Section 79 of the Information Technology Act 2000, providing only technical infrastructure that hosts the platform and does not publish, add, or remove content on the platform, decide which users are vested with certain technical privileges, or continually judge and censor the content posted on the platform, thereby not liable for any third party information, data, or communication link made available or hosted by it. Court said we are not inclined to examine this aspect of the matter since it may have a bearing on the proceedings of the pending suit.